Hi, this is Cora Stack here, Dr. Cora Stack. I just wanted to talk here about breaking news, and that is something I'm really happy about because I'm looking for support for my own constitutional case, which has a huge overlap with this one, and it's called Save the Separation of Powers and Protect Democracy campaign. So if anybody has anything left to spare after Christmas, I'd greatly appreciated support for that fund. That would be greatly appreciated. It's on GoFundMe, so I'm obviously out of everything, out of the air. But let's see what I've my position really on what's come from the Supreme Court and their opinion here. And in my opinion, there is some kind of a logical contradiction, and it's like mathematics. When you're reading a math paper, reviewing a paper, say, you find something, say there's something not right here. So let's just see why I'm having that problem here. With what the Supreme Court said, even though I completely agree with them on one point, and I particularly agree with them on focusing on Article 12, I definitely think that is the one to look at here rather than the whole lot together, or there's no need. It's like a counter example in mathematics. You just need one. You just need one to get a proof, right, to get a contradiction. So same thing, breach. So that's how I see it. So breaking news: Supreme Court leave to appeal the two nomination routes, the block, and why Article 12 must be heard. Well, it is being heard now. Hi, and thank you for taking the time to listen. You know who I am at this stage, Dr. Stack, and I'm again trying to do a deep dive into this to try and understand why I have this problem, that there's some kind of contradictory something in this that's somewhat contradictory, and I want to try and get to the bottom of it. And I'm sure I won't get to the bottom, but at least I can kind of raise it, and I'll be another week trying to figure out this. But let's up until the early hours. Today, I want to explain an issue that is constitutionally serious, but often described in a way that is perhaps confusing, incomplete, or vague. This follows the decision, which I very pleased about, of the Supreme Court of Ireland to grant leave to appeal in a case concerning, particularly given that he's a litigated person. It's almost impossible, it's an incredible achievement to grant leave to appeal in a case concerning the presidential nomination process brought by Mr. Niall Byrne, a businessman, and proceeding under Article 12 of the Constitution. I agree with that this is the one to examine whether this article has been breached. But there is a slight contradiction in what I see coming out from the Supreme Court. And I'm not saying that I'm right, certainly not. I'm just saying that I have something like a mathematical contradictory sense there that I'll just try and explain it here. But that doesn't mean it's there's anything that how that maps onto the constitutional issue. I haven't explored that yet, so I'm not at the this is kind of like something that I now have to explore from a mathematical sense of something contradictory to a constitutional issue. That's a path I haven't gone yet in terms of investigation. So what I want to do in this video is explain clearly and factually, well, we've done this before, what the two nomination routes actually are, what constitutional provisions govern them, what happens when both the nomination process and the upcoming election are challenged. So both of those were challenged by both myself and Mr. Byrne. Both of them, the nomination process and the upcoming election, were challenged before the election. How lower courts have dealt with these challenges in practice, why a block arises because of timing and sequencing, and why this issue is central to a joint paper by myself and Ms. Maureen Kenny. This is not about personalities or politics, it's about constitutional structure, and we'll just kind of go into it in this way. The Constitution, again, provides two nomination routes for the presidential election. Under Article 12, one is to ensure pluralism, which I think is extremely important, and it's central to democracy. Under Article 12 of the Constitution of Ireland, formerly known as Oireachtas and Héireann, there are only two lawful routes by which a person can be nominated as the candidate for president. There is no popular petition route. There's no citizen. No, there isn't. This like there's in other countries. Route 1, nomination through the Oireachtas. The first route allows a candidate to be nominated by either 20 members of the Oireachtas, meaning TDs and/or senators. This route is politically mediated. In practice, it requires party support or agreement from sitting parliamentarians. Now, one independent, Miss Maria Steen, almost made it, but didn't. But this is extremely rare. For independent candidates without institutional backing, this route is often closed, effectively closed. So the second route then is for the ordinary person, and it's a kind of a check on the other route. It's a check, and it's really from the people. It's coming from the people rather than the parties will have their people, and then what's coming through the other route is from the people. And you can see the difference. There's a balancing of it's just very clever, really, the balancing between the two. It was a clever design, I think, in the original constitution. Which has served reasonably well for up to now. Route 2, nomination through local authorities. The second route allows the candidate to be nominated by 4 county or city councils. This route is often described as the independent route, but in reality, well, we know that local authorities are partially controlled votes, and the access is highly constrained. But once the presidential order is issued, then everything moves into a constitutional role rather than a party political. So somebody that's acting, in many ways for the party in other areas, once the presidential nomination order for the presidential election, the counter-counters become constitutional actors. They have to, be concerned with their constitutional duties under the regulations that are imposed on them by the CEPU standards, etc., etc. So this route is often described as the independent route, but in reality, there are 2 routes then, the 20 Oireachtas or 4 local authorities. I think that the point about once the presidential order is, which is part of the process, everything moves from party to constitution. So the whole process moves from all the actors and the decision makers in that process have to act in accordance with their constitutional obligations under various standards and acts and so on. So what Article 12 is meant to guarantee, Article 12 does not merely list procedures. It constitutionally guarantees that the nomination process is real, not illusionary. Access is meaningful in substance, not just in form, and that the democratic structure complies with constitutional standards of fairness. This is where structural constitutional errors arise. What was actually challenged, and this is important. Now, this is where I have the contradictory issue, inverted commas, with what came out of the Irish Times article. In Mr. Byrne's case and in related litigation, 2 connected issues were challenged at the same time, and this was before the election. First was the constitutionality of the nomination framework itself, meaning whether these 2 routes, as designed and operated, are compatible with Article 12. When the challenges were in the courts, which was before the election. Second, the lawfulness of proceeding with the upcoming presidential election, if that framework is unconstitutional. In my opinion, these 2 issues are logically inseparable. This is where I have the logical contradiction, inverted commas. If the nomination process is unconstitutional, then proceeding with an election under it raises a further constitutional problem. What the lower courts appear to do in practice, this is where my difficulty arises. In practice, lower courts repeatedly declined to engage with both issues together. What tended to happen was courts emphasised urgency in the electoral timetable. They declined to restrain or pause the election refused. Challenges were dismissed on the grounds of, in Mr. Byrne's case, they were considered non-justicable or personal, framed as personal grievances, and other reframing strategies were used. or are refused on timing and practicality grounds rather than full constitutionality. So it wasn't that the constitutional issues were kind of sidelined and they were reframed the case as being something which they weren't, in my opinion. And this is a kind of, and then a doctrine, there's a doctrine from one case that was fed into another case, so that kind of hardened the doctrine. But, the fact that an appeal is now being heard meant that the doctrine that went in from one case to the other is highly questionable, because that doctrine wasn't even at the appellant stage before it was included in the second one. So that compounds the difficulty as well. And this is a very, again, very subtle. Challenges were just, as a result, the election proceeded, a president was elected, and the president entered office. What happens once the president enters office? At that point, a specific constitutional provision applies. And I think this is what the Supreme Court are saying. Article 12.44 states that the president shall not cease to hold office until his successor shall have entered upon office. This provision is embedded in the Constitution itself. It guarantees continuity of the presidency. It is automatic. It is not judicial discretion. Once a president has entered the office, the outcome of the election is constitutionally insulated. I think that's the point the Supreme Court are making, and the courts will not disturb it. But let's turn it around. This is where I have the issue. Again, it's more mathematical, I suppose. The contradiction stated plainly. This produces, in my opinion, and I'm only, a mathematician, a serious constitutional contradiction. Before the election, courts refused to intervene because the election had not yet occurred and must proceed. After the election, courts refused to intervene because the election has occurred and cannot be disturbed. So the obvious question is, what exactly is the constitutional challenge meant to be heard? This is the core problem. How the issues gets narrowed. To manage this contradiction, lower courts have tended to reframe the case. They say this is really about the nomination process. The election itself is not justicable, but that is artificial. I'm wondering, is this what the Supreme Court are saying? The lawfulness of the election depends on the lawfulness of the nomination process. This is the mathematics in saying this. One follows the other. To separate them is not constitutionally neutral. This is the point I'm making now. It's just an argument, and I'm just putting it out there for consideration. The block and the cascade. The result is the block. The structural Article 12 challenge is not resolved before the election, cannot be resolved after the election, and therefore remains unanswered. What happens next is a cascade. Unresolved assumptions. This is something now that has been identified in the way my work, the way I think, that I'm able to see these kind of patterns in a way perhaps that others mightn't, or see these inconsistencies. What happens next is a cascade. Unresolved assumptions remain in place. High Court reasoning that was never tested by the Supreme Court hardens, and that reasoning is then treated as settled doctrine in later cases. I mean, this is what happened in my own case. Unsettled doctrine was imported and applied against me, making my case weaker than it was, without ever having been authoritatively determined by the Supreme Court. Why this is not about removing a president. It's essential to be clear about this. This argument is not about removing a president, overturning an election, or destabilising the state. Article 12 prevents that. Continuity of office. This issue is whether the Constitution provided a real and effective opportunity to examine structural defects before continuity closed the door. Why the Supreme Court decision now matters. This is why the Supreme Court decision to grant appeal now is so important. It signals Article 12 issues are justicable, unresolved assumptions cannot simply be carried forward, and constitutional scrutiny cannot depend on timing accidents. It addresses the structural problem identified in papers between myself and Ms. Maureen Kenny, that a constitutional safeguard that exists only in theory is not enough. This is not a political argument. It's not an attack on institutions. It's a constitutional question about access. Well, I have a huge thing about access to justice and fairness anyway. That's just, and structure as well. And it's precisely the kind of constitution that belongs before the Supreme Court. Thank you for listening. I will continue to update you as developed. But I want to go back to that point again, because this is what's gnawing at me, being the mathematician, the digs for understanding. And I will just go back to the this point here. What the lower courts did in practice, this is where the difficulty I have arises. In practice, the lower courts, which are the high courts in this case, is the first course you can take these challenges. Lower courts declined repeatedly, well, in two cases, declined to engage with both issues together. So both issues were the constitutionality of the nomination framework itself and the lawfulness of proceeding with the upcoming presidential election if that framework is unconstitutional. Let me go through that again. First, the constitutionality of the nomination. My brain is fried from all of this complexity. I'm sure it's complex. It is complex for all concerned. Even judges would find this, because it's novel. It's all novel in terms of the Irish political situation. So I'm trying to do the sequencing here to see can I get clarity where I feel it's blurred at the moment. First, and trying to do the sequencing and seeing one follows the other, and how can you narrow it down to one without looking at the two kind of in sequence. First, the constitutionality of the nomination framework itself, meaning whether these two routes are designed and operate to be compatible with Article 12. I think that is something that we all agree on, but second, this is the issue where I have the problem here: the lawfulness of proceeding with the upcoming presidential election if that framework is unconstitutional. So if one is unconstitutional, what does it say about the lawfulness of proceeding with the upcoming presidential election? So if that is what's bothering me, kind of from a logical point of view. These two issues are logically inseparable. So this has never been tested by the courts. So this is the difficulty that I'm just putting forward for consideration. I feel that the courts have narrowed the question down to point one there, the constitution of the nomination framework itself, meaning these two routes are designed and operated. But what they don't seem to be saying is that the lawfulness, addressing the lawfulness of proceeding with the upcoming presidential election if that framework is unconstitutional. It seems to me that these two are logically inseparable, but whether that maps onto constitutionally inseparable is a very tricky. It's a very tricky one in view of that it's very complex. If the nomination process is constitutional, then proceeding with an election under it raises a further constitutional problem. So that's where I have the issue with, that's where I have the mathematical something here that's not quite right, and that kind of squares it, but I haven't gone into that in enough detail, and I will update you on further clarity on that in due course. And I am doing a GoFundMe, and it's called Separation of Powers, Protect Democracy, and if anyone would like to contribute to that campaign, that would be greatly appreciated, because it's been really challenging as lay litigants to go in front of the state and to make our case that this sort of case now, even to tackle it as something with regard to what has been reported about what the Supreme Court are going to look at the moment. I mean, whether these points have been raised or not, but you see, it's an incredible election. There's no question. There's been so many issues. You'd say, wouldn't it be the easiest thing to kind of start again? And I'm sure Billy Kelleher and Sean Kelly and all of those would be delighted to have a second election. But that is not something for us. We're just looking at constitutional questions, and how they're interpreted by the Supreme Court is not a matter for us. We have to bring our concerns to them and ask what their view on it is. But I am saying that there's more to it than is coming out now from the Supreme Court's logically, from a mathematics point of view and a logical point of view. And I keep mapping my mathematics onto the various constitution and seeing logical defects, perhaps or design problems, and I'm just raising it now, and I haven't investigated enough to but there is something there definitely, and I have more work to do on that, which I don't want to do because I'm exhausted from all the research up, until 2 and 3 in the morning writing papers, and it's just too much. So anyway, it's fascinating. It is one of the most fascinating elections I've ever, I have ever, come across ever, in terms of so many things, so many unfortunate mishaps right throughout, and I'm sure everybody was. Most people were well intentioned, but just one slip, one major slip, or one timing thing, and it just seems to have cascaded into major problems for a lot of people. So this election won't be forgotten for a long time. So if anybody could support me on, I've named my because I'm looking around now and looking at. I didn't realize actually how important the separation of powers was until I looked around and saw what's happening elsewhere around the world. And, it's extremely important that in democracies that there is the separation of powers isn't weakened or thinned by, reframing or reclassification of cases, that's going on a lot around the world, and it's really weakening democracy. And the more that's thinned, the more the executive takes control of power, and that becomes more like a dictatorship. I mean, it's an awful thing to say, but that's exactly in practice what happens. So, big institutions, etc., have more and more power if the courts have less and less. Less are thinned out or weakened. So it's very important that we understand. I mean, I really am only now coming to the view that the separation of powers is absolutely critical to keep that as wide as possible. Rather than this reframing, thinning it out. It is so important for democracy and the health of our democracy to save the separation of powers. And I'm so glad that the Supreme Court are taking this very seriously, because it is so important for the citizens, for the integrity of the court system itself. It's so important, but also to protect the citizens and in terms of the duties judges have in the courts to adhere to their duties with regard to the separation of powers, and that they are not unduly influenced by other, by other factors, which unfortunately is happening all too much all around the world, and is really weakening democracies over time, slower and slower and slower. So I'm so pleased the Supreme Courts are addressing this issue, but I'm also addressing now the consequential issues from a mathematical point of view, and I haven't crystallized them yet, but I'm working on it. I'm working on that consequential issues, and it's just it's better to have these kind of crystallized in your mind. But certainly they did. The Supreme Courts have raised an issue to be examined in further detail to what was explained in the papers. So looking at that, with others at the moment. So, but certainly I'm not. It isn't finalised in my mind as to exactly. There is something there, about yes, that 4.4 says something, but that there's a consequential thing there given what happened. The story and the sequencing all has to be taken into account in terms of how the Supreme Court ultimately will be asked to deal with this. And obviously I'll have to be working very, very hard over the next while to kind of crystallize that contradiction that's staring at me, but I'm not able to frame it in a way I actually. But anyway, thank you very much for listening and staying with me all of this, because this is so complex. And of course, the more the complex, the more I enjoy doing it. But you do get a stage where it's so complex that it's so hard to explain it when it's this complex. But I want to thank you all very much, and if you can support the GoFundMe for support the separation of powers, protect our democracy. I can't tell you how important this is, that we do not allow our courts to be subject to undue influence by anybody, and that we have to help them stand up for us through the powers that they have. and they are being extremely good now in accepting the leave to appeal in the spirit of appeal to them to that this is so important. So I am really proud of what they're doing, and perhaps the people that will really win the election here will be the Supreme Court, and anyone who has the fortunate experience of getting inside the door with regard to this particular incredible election case.